Thank you very much for joining us. My name is Ian Scott, and today we are going to spend some time talking about the H-1B visa. In terms of at the end of this webinar, we're going to send you a number of different things. One thing that we're going to send you is the PowerPoint presentation, so we will email that to you. We will also send you an H-1B guide. This is a comprehensive guide that has a lot of the things that we're going to talk about today in more detail. And also we'll send you a link where you can sign up for other webinars. In terms of the panelists today, we're lucky to have Kelly Legrand-Wiener, who's the managing attorney of the firm, and Mikhail Vrazdova, who's an associate at the firm. Both have a vast amount of experience processing H-1B visas. Again, my name is Ian Scott. I'm the founder of the firm and will be the moderator. In terms of questions, to the extent that you do have questions, you can put them in either the chat box or you can use the question and answer function. We will get to all questions, and there are a number of questions that people sent in ahead of time as well. And finally, the webinar will be recorded and will be made available on demand. So without further delay, I will turn it over to Michaela and Kelly.
So good afternoon, everyone. My name is Michaela Vrazdova, and as Ian mentioned, I have vast experience processing H-1B visas. So in this first slide, we will go over the basic H-1B requirements. So the first H-1B requirement is that the H-1B worker or the foreign national who wants to come to the US and work for the US company either has to have a bachelor's or higher degree, or has to have a license, or has to have a progressively responsible experience in specialty occupation. So as I mentioned, you either have to have a US bachelor's or higher degree from a US college or US university in specialty occupation, or you also can have a foreign degree from a foreign university, but in this case, you would have to show that the foreign degree is equivalent to at least a US bachelor's degree. Now, with regards to the state license or registration or certification to practice in specialty occupation and the progressively responsible experience in specialty occupation, we do not see as many of these cases. I would say the majority of the H-1B cases are situation when the foreign national has education in the specialty occupation, but it is definitely possible to also qualify through your work experience in the specialty occupation. Now, the second H-1B requirement is that the H-1B worker or the foreign national who wants to come to the US already has to have a job offer from the US employer. So it is not possible to kind of apply for an H-1B visa and come to the US and look for a job. At the time you are applying for an H-1B visa, you already have to have a job offer from the US employer, and the employer has to be willing to sponsor you for the H-1B visa. And the third H-1B requirement is that the position in the US is a specialty occupation. So what this means is basically that not all occupations or not all job positions in the US could qualify for an H-1B visa. So in order to prove that the position in the US is specialty occupation, you will have to meet one of these four listed criteria below. So you will either have to show that a bachelor or higher degree is normally the minimum requirement for entry into the particular position, or that a bachelor degree or higher is common to the industry, or that the H-1B employer normally requires that employees who are applying for the particular position have at least a bachelor or higher degree or equivalent to this degree, or that the duties are so specialized and complex that a bachelor's degree or higher or the equivalent is normally required for the position. And again, just to reiterate, not all positions in the not all jobs in the US could kind of qualify for the H-1B visa. So we will have to show that the position, you will kind of be performing in the US is specialty occupation. And what this basically means is that normally either at least a bachelor's degree is required, or normally a license is required, or you have to have previous work experience that is basically equivalent to at least a bachelor's degree.
Great, thanks, Michaela. A few questions that people had sent in advance, and one of the questions was whether or not the H-1B has any nationality requirement.
No, so it does not. National of any country can apply for the H-1B visa.
Perfect. And another question was whether or not the H-1B was available for people that were engaged in part-time employment.
Yes, so that is possible. The H-1B employment does not have to be full-time, but one thing to keep in mind is that if the H-1B employment is originally full-time and then the H-1B employer wants to eventually change it to part-time, an amended petition would have to be filed with USCIS.
Perfect, perfect. And the last question has to do with the degree, and there's a requirement for the degree, and there's also a requirement for related to the job. And can someone that with, for example, an engineering degree take a job that is in marketing, for example, like as a bachelor's degree in engineering, but then can they get a job in marketing?
Yeah, so unfortunately not. So there has to be a connection between the degree and the job in the US. So if you have a bachelor's or master's degree in engineering, your job would basically have to be in the engineering field.
Great, thank you.
So now let's go over how you can apply for an H-1B visa and what is an H-1B lottery. So unfortunately, there is only a limited number of new H-1B petitions that can be adjudicated by USCIS every year. So USCIS can only adjudicate 65,000 regular H-1B petitions. And on top of that, they can adjudicate additional 20,000 petitions for people who have a higher degree from a US university. And because there is this limitation on how many petitions can be adjudicated every year, this is called an H-1B cap. So the 65,000 that is called regular H-1B cap, and the additional 20,000 petition for people with master's degree or doctorate degree or higher, that is called a master's cap. And one thing to keep in mind here is that this H-1B cap is only applicable to new H-1B petitions. So if you are filing for an extension petition for H-1B employee who is already working for you, or if you are filing H-1B petition for employee who was working for another employer on H-1B status, these petitions, the extension petition and the change of employer petitions are not counted towards the H-1B cap. And just because more than 85,000 petitions are filed each year, USCIS basically has to run what is called an H-1B lottery. And this is basically a lottery where USCIS put together this computer, kind of like computer system that randomly selects 85,000 H-1B registrants that will then be able to file the H-1B petitions. And just to give you an idea, last year around 275,000 H-1B registrations were filed. And from that number, USCIS then ran the lottery and selected the H-1B petitioners who were then able to file the H-1B petition. And in 2020, USCIS kind of changed the H-1B lottery system. And nowadays, the system is completely electronic. So we'll discuss this more on the next slide, but what basically happens is that the H-1B employer who wants to sponsor H-1B employee for the visa has to first file H-1B registration online. There is a period during which this is allowed, and then USCIS kind of electronically runs the lottery and randomly selects the H-1B petitioners who are then able to file the H-1B petition. There are certain employers that are not subject to the H-1B cap. And this means, and I forgot to mention, the H-1B lottery is run each year in March. And so there are certain employers who are not subject to the H-1B cap. And that means that they don't have to go through the lottery system at all. And then they can basically sponsor H-1B employees for the visa at any time during the year. And these are basically institutions of higher education. So for example, universities or nonprofit organizations or governmental research organizations. So these employers are not subject to the cap, and they can sponsor H-1B employees at any time. So now I will go briefly about, I'll discuss briefly the H-1B application process. So as I mentioned, nowadays the H-1B registration process is completely electronic. So USCIS actually announced last week when the registration period will happen this year and when will the H-1B lottery be run in 2021. So basically this year, H-1B employers who want to sponsor H-1B employees for the visa can submit the H-1B registrations from March 9. I think it starts at 12 o'clock at lunch until March 25, 2021, again, until 12 o'clock noon. And so what basically happens is that the H-1B employers during this time will submit an H-1B registration online, and then USCIS will run the H-1B lottery and should notify the applicants or the petitioners who are selected by March 31st, 2021. And last year, how USCIS did it was that they sent an email to the selected H-1B applicants, and then that's how they knew that the petition was selected. And then after March 31st, the H-1B petitioners will basically have 90 days during which they will be able to file the H-1B petition to USCIS. And one thing I just wanted to clarify quickly is that just because your petition is selected in the H-1B lottery, that doesn't mean that the petition is automatically approved. It just means that you have an opportunity to file the H-1B petition to USCIS, and then USCIS will make an ultimate decision whether they will approve or deny the petition. And so how does the H-1B registration system work? So I believe it will be kind of similar as it was last year. So what happened last year was that the H-1B employer had to create an account on USCIS website, and the H-1B employer either could submit the H-1B registration himself or herself, or the H-1B employer can also hire an attorney, and then the attorney can submit the registration on the employer's behalf. The filing fee for the H-1B registration is $10. And again, the H-1B registration will have to be filed during March 9 until March 25th. And unfortunately, if you miss this filing window, then the next opportunity you would have to kind of apply in the H-1B lottery would be next year, so in March 2022. And after, if your H-1B registration is selected in the lottery, then you have 90 days to kind of put the H-1B petition together. So what you will have to do, among other things, is to file what is called a labor condition application with the Department of Labor, in which you will kind of mention details about the H-1B position in the US, information like the name of the H-1B employee, the H-1B employee's salary, and the place where the H-1B employee will be working, and then the Department of Labor will certify the labor condition application. You will have to include the certified labor condition application with your H-1B petition. And for the H-1B petition, you will basically be filing what is called Form I-129 and an evidence that you meet the H-1B requirements, as I explained briefly in the beginning. And you can file the H-1B petition either as a change of status or as a consular processing. So the H-1B petition can be filed as a change of status if the H-1B employee is already in the US on some other status. So what we see often is if the H-1B employee that is being sponsored is in the US on F1 or OPT or STEM OPT and is already here on F1 status, then the H-1B employer can file the H-1B petition as a change of status. But if the H-1B employee is outside the US at the time the H-1B petition is being filed, then the H-1B petition will have to be filed as a consular processing, which means that the H-1B employee will first have to go to a US consulate abroad, apply for an H-1B visa, and only after the H-1B worker has the H-1B visa will he or she be able to come to the US and start working for the US employer. One thing about the consular processing is that as of now, the consulates are currently not issuing H-1B visas. I believe it's until March 31st, 2021. So we will see if the current administration will revoke the proclamation that restricts the issuance of H-1B visas, or if they extend it. So we will see what will happen with that. But that's just one thing to keep in mind if the H-1B employee is currently abroad, and the proclamation that restricts issuance of H-1B visas will still be in effect for a couple of more months. It may take some time until the H-1B worker will be able to get the visa and come to the US and start working for the H-1B company in the US.
Perfect. Thanks. Thank you, Michaela. And there are a few questions on registration and the lottery system. So the first question has to do with the difference between the master's degree and the bachelor's degree and whether there's any advantage. And then the second question has to do with the registration process. And if you do get selected, do you have to apply for an H-1B? And then if you don't get selected, what are your options? Yeah.
Yeah, so people who have master's degree from US university, they do have advantage, because how the H-1B lottery works is that, or how it worked previous years, and I believe USCIS is going to do the same thing this year, is that they first run the lottery for the 65,000 spots, and the people who have the master's degree from the US, they are kind of included in that lottery. And then there is a separate lottery only for people who have master's degree or higher from a US university. So these people do have advantage, because their H-1B registrations can be basically selected in two separate lotteries. So I saw some statistics some time ago, and I mean they should have a higher chance to be selected. Now, if the H-1B registration is selected in the lottery, and whether the H-1B employer has to file the H-1B application. So USCIS indicated that, at the time the H-1B employer is submitting the H-1B registration, the company should have intent to employ the H-1B employee in the future. So they should have that intent at the time they are submitting the H-1B registration. Now, what we saw last year was that, the registration period was in early March, and then COVID kind of got worse. And what we saw was that, some employers, because of COVID and kind of the economic impact on the company, some employers decided not to file the actual H-1B petition because they, lost a lot of money. And then it was fine. But, that kind of happened after the H-1B registration was submitted. So I would say the company should have intent to employ the H-1B employee and file the H-1B petition. But if something, unforeseen happens after the registration is already submitted, the company would have an explanation in case USCIS kind of reaches out to the company why the H-1B petition wasn't filed. And what was just the last question I
And
did?
the last question was whether or not, just give me 1 second, whether or not if you, so we answered if you file. So well, yeah, what are your options if you file and then you don't get selected? What can you apply again in the future, or does it have any impact on that?
Yeah, so if the registration doesn't get selected in the lottery, the next chance to apply is unfortunately, next year in the next year's lottery. So that would be March 2022. And of course, there is the exception for employers who are H-1B cap exempt, and those employers can file H-1B petition for an employee at any time.
Perfect, great, thank you.
Okay, so now we'll briefly discuss some family considerations with regards to H-1B visa and whether H-1B employees' family can come to the US. So H-1B employees' spouse and children who are unmarried and under 21 can apply for an H-4 visa and come to the US. Both the children and the spouse can study in the US. But unfortunately, the H-4 spouses generally cannot work in the US and cannot apply for the employment authorization. There are some exceptions. One of them is, for example, if the H-1B worker is being sponsored for a green card and the immigrant petition is already approved by USCIS. At that time, the H-4 spouse can apply for a work authorization, but generally the spouses cannot work in the US on H-4 status. And now we'll briefly discuss the H-1B legal and the government filing fees and whether the H-1B employee can pay these fees. So with regards to the legal or the attorney fees, the H-1B employee generally cannot pay the fees, and the H-1B employer also cannot ask, cannot pay it himself and then ask the H-1B employee to pay it back. And the fees also cannot be kind of subtracted from the H-1B employee's payroll or anything like that. The H-1B regulations are very, very clear that the H-1B employee cannot pay the fees. There cannot be any side agreement or anything like that. The one exception there is that the H-1B employee can pay the attorney fees for the dependents. So as we discussed, the H-1B employee could pay the attorney fees for the spouse and the spouses and the children's visas, but that would be the only exception to this. And with regards to the government filing fees, so the H-1B filing fees are quite extensive. I would say approximately, a couple hundreds or a couple $1,000s. And again, the H-1B employee cannot pay these fees. And again, there cannot be any kind of like side agreement. The fees cannot be kind of like subtracted from the pay stubs or anything like that. There is, again, one exception, and that is that the employee can pay the premium processing fee. So this is a fee where that can be paid, and USCIS would basically adjudicate the H-1B application in 15 calendar days. And this is not a mandatory fee. It's just if the H-1B employee or H-1B employer kind of want to know the decision on the H-1B petition within 15 days, they can pay the fee, and an H-1B employee can, if he wants, can pay this fee. And now I will turn it over to Kelly, and she will discuss some current H-1B adjudication trends.
Thank you, Michaela. Yes, so in terms of current trends, there's been a lot going on in the H-1B area, ever since kind of 2016. There's been a lot of changes, and now hopefully we'll start to see some, more positive changes as we move into 2021 and beyond. One big change is that ever since 2015, we've seen kind of a increasing requests for evidence, even very significant increasing requests for evidence. In 2019, there were 40% of approved H-1Bs that had RFEs issued. And then overall getting approvals as well has become more difficult. So the government actually does release data each quarter that shows the percentages of approvals and approvals with RFEs and completions with RFEs. And so what we have seen as a general trend is that it's been harder to get approvals, and there have been more RFEs issued. We saw some slight positive changes in 2020 as opposed to 2019. For example, H-1B approval rates rose in 2020 to 91.4%. That was up significantly from 2019's 84.9%. But it still remained well below, 2015's approval rate of 95.7%. So we are seeing things start to move in the right direction, but overall, kind of getting an H-1B, over the past 5 to 6 years has just become a more difficult endeavor, than it was previously, where you could kind of submit, if you had a bachelor's degree and the job required that degree, you could kind of submit that, and that was sufficient. We've just seen a lot more pushback from the government in terms of wanting to see more information. Another current trend is that, and this is potentially one of the reasons for all of the RFEs and some of the increased denials, was the Buy American, Hire American executive order that was implemented, by the previous administration. And this was often cited, kind of as a underlying reason for why there were these higher rates of H-1B denials. So this executive order has now been revoked, by the Biden administration. So our hope certainly is that, things will continue to trend in a positive direction, for H-1Bs. Another thing to mention is that there were many regulations that were kind of pending at the time that the administration switched over. So for example, the definition of specialty occupation that Michaela referenced at the beginning of this webinar, that there was a regulation to kind of redefine that to make it much more difficult to qualify. Similarly, limiting timelines. Normally you can get an H-1B for 3 years, but there were regulations that were in place that were trying to limit that for any H-1B worker who was placed at a third-party site. Changing the definition of employer or employee, changing the lottery system, so it's based on wages. That particular regulation has so far just been kind of moved into the future. So we know it's not going to apply for this year's cap season, which is good news, but we're not really sure what's going to happen to it long term. Some of the changes, like the redefining specialty occupation, those regulations have been modified or kind of withdrawn entirely by the new administration. But we are not sure what will happen with the, basing the lottery system on wages. It's something that may come up later this year, but as I said, will not apply to this year's cap. and is something that also may be challenged through litigation, as many of the changes to H-1Bs have been challenged, and many successfully through litigation over the past 4 years. Right. So what happens, this has become a really relevant question. What happens if I lose my H-1B job? This obviously came up a lot this past year, with the global pandemic. A lot of employers had a lot of changes they needed to make last minute, and a lot of H-1B workers found themselves, in a difficult situation with, their H-1B job being lost. So your options, if you lost your H-1B job or you lose your H-1B job, the first thing you want to do is look at your I-94. What is the end date on your I-94? If you did a change of status in the US, you would get an I-797A that would have an I-94 on it. If you entered with an H-1B visa, you would be able to get the I-94 through an online system. And you want to see what's the end date. So let's say you have an I-94 that ends in 2023. You would then have a 60-day grace period where you can kind of decide, you can stay in the US, you can't work, but you have, you have some time. And really your options when you lose your job, your H-1B job, which is the basis for staying here, are: one, you could depart the United States. Two, you could look for a new job, have a new employer file a change of employer H-1B petition, or you could change to a different visa status, meaning either a work status, or if you have a spouse here, you could change to a dependent status, or something like a tourist status, even if you just want to kind of have some additional time in the US as a tourist before you leave. Perfect. So what are the H-1B grace periods? So this was a really positive change that happened in January of 2017. Prior to that, there was a 10-day grace period and kind of some unofficial guidance about grace periods, but there really wasn't any official grace period. So it meant that if you lost your job, pretty much the next day, you were not in status and you would really have needed to leave the United States. So, in 2017, with the advent of these new regulations, there was a 60-day grace period put into place. And the way that grace period works is that H-1B visa holders and their dependents are eligible for this grace period when employment ends unexpectedly prior to the validity period. And so this applies both to people who have been terminated, and to people who quit their jobs. So if you had a 3-year H-1B and you quit your job, you could still be eligible for the grace period. It applies either way. The one thing to keep in mind is they do have in the regulations that this is kind of a discretionary grace period. So that means that the government is allowed to eliminate or shorten the 60-day period as a matter of their own discretion. We've never seen them do that. The grace period was put in place to assist people with these job transitions. And DHS and USCIS have tended to adjudicate, cases where you're trying to change status or change employers accordingly. But it is in there, so they do reserve that right to themselves. If there was some reason that they felt they should exercise their discretion to not allow this grace period, that is a very, slight, if unlikely, possibility. Something else to keep in mind during the 60-day grace period is that you are not allowed to work during this grace period. So until you have a petition filed on your behalf, for an H-1B, or until you've changed into a new status that allows you to work, you cannot work on the grace period, but it does permit you to stay here and does permit you to change status. Another grace period that was also entered into the regulations in January 2017 was this 10-day grace period. And this works a little bit differently. What this means is that when you get your H-1B approval notice, let's say that your employer asked for you to start work on February 15th and end work, February 15th, 2023, they could give you on the approval notice 10 days prior to February 15th and 10 days after February 15th to allow you to stay in the US. Similar to the 60-day grace period, you can't work during these 10 days. The 10 days are really there to give you, some space to enter the US right before your job starts and to leave the US once your job ends. Additionally, you want to keep in mind that even if you enter the US, with your H-1B visa stamp and your approval notice, the I-94 that is on that Customs and Border Patrol gives you is what's going to control. So even if there was a 10-day, grace period added in on your, your I-797A approval notice from USCIS, if the latest I-94 you got from Customs and Border doesn't have that 10-day grace period, you need to abide by that, or you need to ask them to change it to give you back those 10 days. Another thing that I just want to mention quickly about the grace periods is that sometimes people have the impression that you are able to kind of have the 60-day grace period and add the 10 days. So I just want to clarify that that's not how they work. They operate independently of one another, and it's not the case that you can have your 60-day grace period and add 10 more days. It's really one or the other, and they just operate independently and have different different reasons why they're used. Perfect. So how many times can you renew an H-1B visa? So generally, the rule is that you can be granted the visa for up to 6 years. You can get it in 3-year increments. However, the time that you're granted, the visa for is going to depend on the length of the job offer. So if your employer is only giving you a 1-year contract, then you're not going to be given 3 years automatically. It's going to be based on the amount of time that your employer provides on the filing with USCIS. Another thing to consider is that when if you're coming up on using up your 6 years, but you've spent time outside the US, you can do something called recapture some of that time. So let's say that you've been working for the same company for 6 years, but every summer you take a month-long trip to Europe. So that month period of time that you were outside the US is something you can recapture by filing a petition with the government and getting that time back. And the way that you do that is you file a petition that has proof of your travel history. So that's something you can usually get from an online government site. Additionally, you can have other proof, passport entry stamps, even plane tickets. So any supplementary documentation of your trips outside the United States, you want to hold on to because that can be a really helpful thing, especially if you're going through the green card process and you just need to buy some extra time. It can be helpful to do that just throughout the process to keep track of those documents. All right, so then the other thing that can get you beyond the 6 years is there are some exceptions to the 6-year rule, and those are largely based on people who are going through a green card process with their employer. So for example, one exception is called the lengthy adjudication delay. And that's where you can get an additional 1-year extension if 365 days have passed either since the filing of a labor certification with the Department of Labor or the filing of an immigrant visa petition and I-140 with USCIS. So if those things are still pending and it's taking a long time for them to be adjudicated, you can get 1-year extensions while you wait for the results of those adjudications. If they, of course, are adjudicated negatively, then the ability to extend will go away. The other exception is called the per country limit exemption. And for this one, you can actually get a 3-year extension. And this is really relevant for people who are in categories that are backlogged. So for many Indian and Chinese nationals, the normal green card categories, EB2 and EB3 are quite backlogged. That means if they got an I-140 approval today, with a priority date of, a year prior, they may not be able to immediately file for a green card application. A visa is not available to them yet. So what this exemption allows is that based on that approved I-140, they can go ahead and continue to extend their H-1B status. So this allows them a path to stay in the United States, continue to work for the company while they wait to get to the point where a green card is available to them. And then once it is, then they would be able to go ahead and file that green card. But in the interim, they could still extend their H-1B. And this is, I think, a really, really helpful tool that can often be used, to help people extend their H-1B status while they wait for, a green card category to become available to them. Perfect. So do you need an H-1B to apply for a green card? The answer is no. You don't need to be on an H-1B to apply for a green card. It's not an absolute necessity that you have an H-1B visa before you apply for a green card. However, it can be helpful. There's a reason why many people do go from H-1B to the green card, and there are some benefits to doing it. So for one is that the H-1B visa allows for something called dual intent. This means that, even if you apply for a green card, you're not going to have any issues traveling in and out of the US. You don't have to prove you have a foreign residence abroad that you don't intend to abandon. So, there are other visa types, for example, a TN visa, where you do have to prove that you have non-immigrant intent. The H-1B doesn't require that. So if you have an immigrant, petition pending, or you're somewhere in the green card process and you're on an H-1B, there's no issues with that. You can travel freely. Additionally, the H-1B visa has normally when you file a green card application and you want to travel outside the United States, doing so will mean you abandon your application. Prior to traveling, you have to get something called advanced parole authorization. So for an H-1B visa, and this applies to the L visa as well, it's a special circumstance where actually you can travel on the H-1B visa, even with your green card pending, without abandoning your petition. There are some special requirements. You have to be coming back to work for the same H-1B employer. So it's something that you want to discuss with Immigration Counsel if you do have a green card petition pending and you want to travel. But the H-1B is just, special in that way where most people will require advanced parole, and as an H-1B visa holder, you may not require that. And then the other benefit, obviously, which we talked about briefly previously, is that if your immigrant visa category is backlogged, if you're on an H-1B, you can continue to extend that H-1B, while you wait for the immigrant visa to become available. So there are other visa types, the L visa, for example, where kind of these, extensions are not available. And so that's, there is a benefit. And then there's other visas as well, where it's not, if you have an immigrant petition pending, it can become an issue in terms of renewing that visa, like a TN. So you do want to, sometimes the benefit to being on H-1B status is that you can continue to extend and there aren't any issues with intent. I see someone asked a question, is an L-1B visa holder eligible to apply for a green card? Yes, they are, similar to how kind of anybody can apply for a green card if there's a category available to them. An L-1B does not lead to a green card the same way an H-1B does not lead to a green card. But yes, you can go through the green card process, if the green card category is available to you. And we'll talk about that green card process right now. So what is the green card process, after an H-1B? So the most common way is that your employer will sponsor you through something called the PERM process for an EB2 or an EB3 green card category. In the PERM process, the employer will test the labor market to determine if there's any willing, qualified, and available US workers. If none are found, the employer will file a labor certification with the Department of Labor. That entire process can take several months. It's something that you want to kind of discuss with your employer because they'll really be the ones running that process. As the H-1B or employee applicant, you really can't be involved in it. Then once the labor certification is approved by the Department of Labor, your employer can file an I-140 with the government. That needs to be filed with proof that they have the ability to pay the prevailing wage for the position and proof that the H-1B applicant meets all the requirements in the position. So degree requirements, experience requirements. And then if a visa is available, the employee can simultaneously apply for a green card from within the US through a process called the adjustment of status, or from outside the US with what's called the National Visa Center, and then that petition gets sent to a US consulate abroad. So that's the consular processing process. And so that's the normal process, I'd say, for H-1B workers who are going through the green card. Mm-hmm. So do I have to prove that the company cannot find US workers for an H-1B? So this is not a requirement for the H-1B visa for the majority of employers. As we just discussed on the green card side of things, that is a requirement. You do have to test the labor market if you're going through the PERM process. The employer does have to interview, US workers to determine, are they willing, qualified, and available for this job. For the H-1B, that's not the case, except in very limited circumstances. So there are H-1B employers called H-1B dependent employers and willful violators. And for these employers, they have to attest that they are not going to displace US workers, and they do have to take steps to recruit US workers for an H-1B petition, a position before filing the petitions. And so, this is really the, not very common. This is for, H-1B dependent employers or those who have a, kind of higher percentage than normal of H-1B workers. There's a, mathematical calculation you can do depending on the number of workers a company has versus the number of H-1B employees it has. And then if, for a willful violator, that's someone that the Department of Labor or the Department of Justice has found has committed willful failure or misrepresentation of material facts. So in that case, if there's been an agency finding of those kinds of issues, those employers are required to attest on the labor certification, that they have taken steps to recruit U.S. workers before they file an H-1B petition. But I'd say for the vast majority of H-1B petitions and H-1B employers, this is not the case. It's only relevant for, for the perm process when you're going through the green card process. Perfect. Let's see. We have one other question. What is the advantage of an H-1B employee over an L category in the process of a green card? So I think that, one benefit to the H-1B, I'd say they have a lot of the same benefits, in the sense that they're both dual intent visas. It is important to keep in mind that any time you spend on L status counts against your 6 years for H-1B. So, that's just something to keep in mind. Like if you've reached your max time on an L, you can't just switch to H-1B. But one benefit to the H-1B is that there is this ability to get these extensions if you're in a category where the visa is backlogged. So that's not available for the L. Whereas if you are on if you switch to an H-1B and you have an approved I-140, then you can, and your category is not current, you can continue to ask for these 3-year extensions in the H-1B, whereas that's not available to you on the L. I think that is all the questions that we have.
Excellent. Perfect. No, thank you very much, Michaela, and thank you very much, Kelly. Excellent presentation. A lot of great information. As I mentioned at the beginning of the webinar, we will send out an H-1B guide. We'll also send out a link where you can sign up for future webinars. And we will also send you the link to see this recording. So the recording will be made available on demand. And again, thank you very much.